by accepting appointment as an assistant professor with Plaintiff's Department of Obstetrics and Gynecology, which also functions as a practice group. Defendant agreed not to practice medicine within 30 miles of the city of Albany for a period of 5 years after leaving its employ. 5 years later, although defendant's income had doubled in the interim, the parties were unable to resolve defendant's complaints concerning his compensation and the facilities and staff provided to him, and he resigned to open his own practice nearby. In response, plaintiff commenced this action seeking to enforce the restrictive covenant and moved for a preliminary injunction during the pendency of the action. Defendant cross-moved to enjoin plaintiff from enforcing the covenant, alleging that he is the only fellowship-trained physician in the Albany area who can coordinate conditions within his subspecialty of urogynecology and reconstructive pelvic surgery, and that plaintiff's breaches of the employment agreement bar its enforcement of the covenant. Supreme Court granted plaintiff's motion and denied defendant's cross motion, prompting this appeal. It is well established that such a covenant will be enforced if it is reasonable as to time and area necessary to protect the employer's legitimate interests, not harmful to the public and not unduly burdensome. Also, our review is limited to determining whether the lower court's discretionary powers were exceeded or, as a matter of law, abused. Furthermore, a motion for a preliminary injunction need not be denied even if there is an issue of fact as to a necessary element. Instead, the trial court is to determine by hearing or otherwise whether the requisite elements are present. Initially, we cannot agree that Supreme Court abused its discretion by resolving the issue of whether the public would be harmed in plaintiff's favor without conducting an evidentiary hearing. While defendant's submissions arguably raise an issue of fact as to whether he is the only fellowship-trained physician who provides treatment for all of the medical conditions peculiar to its subspecialty, he failed to effectively dispute the assertion by Barry Cogan, chief of Plaintiff's Division of Urology, that all of the conditions listed by defendant can be treated by members of the plaintiff's staff, that with only one exception, the procedure performed by defendant was also performed by Dave Das, a board-certified urologist, and that Das performs an alternate procedure for the condition treated by the one procedure unique to defendant. None of the physician's affidavits submitted by defendant states that Das does not or is not qualified to perform these procedures. Nor can we agree that plaintiff's alleged failure to provide adequate staffing and compensation preclude it from enforcing the restrictive covenant in view of defendant's continued performance of the parties' agreement. A party to an agreement who believes it has been breached may elect to continue to perform the agreement and give notice to the other side rather than terminate it. When performance is continued and such timely notice is given, the non-breaching party does not waive the right to sue for the alleged breach. However, by choosing not to terminate his contract at the time of the breach, the non-breaching party surrenders his or her right to terminate later based on that breach. In this case, the construction worker who injured his right arm while working on state-owned bridge brought action against state. The Court of Claims denied the state's motion for summary judgment over the scaffold law claim, and the state appealed. The Supreme Court Appellate Division, Mercure, Justice presiding, held that the worker did not establish that his arm was injured due to his short fall while working on the bridge as required under the scaffold law claim. The order is modified, and as so modified, affirmed. The construction worker did not establish that he injured his right arm as a result of his short fall while walking on state-owned bridge as required for the scaffold law claim against the state. Rather, all medical reports and workers' compensation forms prepared in connection with accident embodied workers' statement that the injury to his right elbow and forearm was caused when he drilled a foreign object into the drill bit and it broke, and his right arm became entangled in cord and twisted with the drill before he fell.
Drill bit. Is drill bit one word?
2 words.
Non-breaching, that's one word.
Forward?
Non-breaching party.
Yeah, none is always one word. Except before a name.
Okay.
In fact, you could define that, none, as
Yeah, I
none
actually,
hyphen delete space.
I do.
No hyphen, none delete space.